Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will look at one of the most significant cases ever decided by the High Court of Australia. The decision was from 2006 and it relates to the corporation's power of Section 5120. That's right, we're talking about the work choices case. We have already analysed Section 5120 of the Australian Constitution, the corporation's power. Make sure to watch the video that we did about it, because there we explain the scope and the idea behind the corporation's power. In this video, we'll be looking at the implications coming out of the corporation's power in practice, and how did the High Court decide this significant case called the work choices case. So let's start with the facts. There existed this act from the Commonwealth called the Workplace Relations Act from 1996. This act, as the name says, dealt with workplace relations. In 2005, however, the Commonwealth enacted the Workplace Relations Amendment Work Choices Act from 2005. This act, among other things, restructured the workplace relations for constitutional corporations. The most notable difference between this amendment and the first act was on the grounds, the basis upon which the enactment was made. You see, whereas the Workplace Relations Act from 1996 had been based primarily on the conciliation and arbitration power of Section 5135, the majority of the provisions in the amendment were now relying on the corporation's power of Section 5120. So, although some of the provisions were still based on Section 5135, conciliation and arbitration powers, the new Act was now in a large part an exercise of the corporation's power of Section 5120. In this context, there were 7 actions brought before the High Court, 5 by states and 2 by trade unions. All of them sought the invalidity of the new Act. The principal object of the contention related to sections 3, 4, 5 and 6 of the new Act. These sections said that the constitutional corporations, those corporations that fell within the scope of section 5120 of the Australian Constitution, were to be characterized as employers and thus subject to the newly established framework for cooperative workplace relations. That is, that those constitutional corporations will be subjected to the same framework, the same workplace relation rules as any other corporation. In a nutshell, in its practical application, the new Act depends in large measure upon the assumption that the corporation's power is capable of sustaining the legislative framework. So the question before the High Court was, can the Commonwealth use its corporation's power to regulate the relations of corporations broadly? Is a law that provides that a constitutional corporation must pay their employees a certain minimum wage and must provide them with certain leave entitlements and must require them not to work more than a certain number of hours, a law with respect to constitutional corporations under Section 5120? The High Court of Australia, by a majority of 5-2, with Justices Kirby and Calliner in dissent, upheld the validity of the Act. They decided to interpret the provision broadly and give an ample meaning to the text of the Australian Constitution. So, Section 5120 shouldn't be read down like it would have happened prior to the engineer's case. Like it had happened in a case called Hurdat Parker from 1909, when the High Court read down the provision of Section 5120 in light of the provision of Section 51.1. No. After the engineer's case, as you know, the text of the Constitution was to be given the widest possible meaning. Thus, the corporation's power should include the power to legislate about anything related to the constitutional corporations. This interpretation had already been hinted by another case called Strickland and Rockler Concrete Pipes from 1971, known as the Concrete Pipes case. Also, in another case after Concrete Pipes, called Ray Dingson from 1995, Justice Gaudron had expressed Her Honour's interpretation of the corporation's power in a wider meaning. 5 years after Dingjan, in another case called Pacific Coal case, Her Honour once again expressed her position to give a wide interpretation to the corporation's power. Listen to what she said. The power conferred by Section 5120 of the Constitution extends to the regulation of the activities, functions, relationships, and the business of a corporation described in that subsection, the creation of rights and privileges belonging to such a corporation, the imposition of obligations on it, and, in respect of those matters, to the regulation of the conduct of those through whom it acts, its employees and shareholders, and also the regulation of those whose conduct is or is capable of affecting its activities, functions, relationships, or businesses. All in all, as Her Honour said, the corporation's power of Section 5120 extends to laws prescribing the industrial rights and obligations of corporations and their employees and the means by which they are to conduct their industrial relations. This dissenting opinion that had been expressed in Dingjan and was repeated once again in the Pacific Coal from Justice Gaudron was the basis that the High Court used in the work choices case. So the High Court rejected those arguments that related to the federal balance, or saying that there were certain matters that were reserved to the states. They followed the literal approach of Justice Gaudron to say that anything related to a corporation would fall within the scope of the corporation's power of Section 5120. Of course, the High Court would not prevent the states from operating as states because of the Melbourne Corporation Doctrine, but it nonetheless recognized a broad power to the Commonwealth to legislate about corporations. Anything concerning the relationships that a constitutional corporation might engage with, or anything touching upon Section 5120, a constitutional corporation, could be legislated by the Commonwealth. Hey, if you're liking this video so far, if you think it's useful, make sure to click the like button. That's super helpful for us. And also, subscribe to our channel. Although Justice Kirby and Callanan tried to persuade the rest, talking about the balance of the Federation and how the Constitution depended on the federal structure, the High Court, the majority of the High Court, decided to follow the engineer's case and adopt the textual, literal approach to interpreting the provision of the Constitution. And once more, that method of interpretation ended up expanding the powers of the Commonwealth. The majority rejected the intentionalist interpretation of the Constitution, saying that the framers wanted to limit the scope of the corporation's power. Their owners also rejected that a failed referendum that happened before to try to alter the scope of Section 5120 should be taken into consideration, because that was an extrinsic matter to the Constitution. And they also rejected the argument that was once established by the High Court before the engineer's case, that there existed an internal and an external aspect to the corporation's power. This sought to limit the power of the Commonwealth Parliament to legislate about corporations only to the external relations, to the external acts of a corporation. But this was here rejected by the High Court. So, what did the High Court decide in the work choices case? The new act was valid, it had an appropriate head of power, and therefore it could regulate the relationships, both internal and external, of the constitutional corporations. This is another example of how the literal interpretation to the Constitution has extended the powers of the Commonwealth and has expanded the scope of a constitutional provision, Section 51. Thank you for staying until the end. I hope you enjoyed it. I hope you've learned something new about constitutional interpretation and about this very significant case in Australia's history. Don't forget to click the like button and to subscribe to our channel. And I hope to see you next time. Until then, ciao.